May it please the court, my name is Sydney Von Arx, and beside me is my co-counsel, Elena Lee. The question before us today is whether the Eighth Amendment's excessive fines clause should be incorporated through the 14th Amendment's due process clause or its privileges or immunities clause.
The facts of the case are as follows. Tyson Timms was arrested and convicted of a Class B felony dealing in heroin and the felony charge of conspiracy to commit theft. To transport the heroin, he drove his Land Rover, valued at $42,058.30, over 16,000 miles. He received a sentence of 6 years, paying $1,203 in fees. A civil trial in which the state seized Timms's Land Rover in an act of civil forfeiture leads us to the question of the incorporation of the excessive fines clause and of whether the forfeiture of Timms's vehicle was a violation of that clause. The Bill of Rights contains those rights most fundamental to a free republic. Although the Bill of Rights only applied to the state governments, not the federal government, upon its ratification, almost all of the rights contained within have now been incorporated to the states using the Due Process Clause of the 14th Amendment. In the case before us today, we contend that the excessive fines clause should join this list of incorporated rights, and that the method of incorporation should be the Due Process Clause and not the Privileges or Immunities Clause. While we acknowledge that the protection against excessive fines is a fundamental one, we do not believe that the seizure of Tyson Timms' Land Rover qualifies as an excessive fine due to precedent regarding civil forfeiture and the fact that Timms used the vehicle extensively for committing 2 felonies.
Should the Eighth Amendment's excessive fines clause apply to the states?
While the incorporation of the Eighth Amendment's protection against excessive fines has not yet been explicitly ruled on, precedent in this case is clear. The Supreme Court has so far incorporated every enumerated right in the Bill of Rights except the Third Amendment, the Sixth Amendment's guarantee of indictment by grand jury, the Seventh Amendment's right to a jury trial in civil cases, and, of course, the Eighth Amendment's protection against excessive fines relevant in this case. The incorporation of these rights depends on the standard set in Duncan v. Louisiana that stipulates that a right must be, quote, fundamental to the American scheme of justice to be incorporated. The excessive fines clause surely meets this criterion. Without such a protection, state governments could exact damaging fines from the people, leading to a judicial system that is more interested in extracting punishments than in maintaining order and fairness. The court has come to the same conclusion on excessive fines already in the case of Cooper Industries Incorporated v. Leatherman Tool Groups Incorporated. Other parts of the Eighth Amendment have also been incorporated. For example, the Cruel and Unusual Punishment Clause in Robinson v. California and the ban on excessive bail in Schilb v. Kubel. It only stands to reason that the excessive fines clause should be incorporated as well, but through the due process of law, not privileges or immunities, as the petitioner argues.
Please explain what the Due Process Clause of the 14th Amendment prohibits. Why is it the most appropriate vehicle for applying federal constitutional rights to the states?
The court has long held that the Due Process Clause ensures that the state follows a proper legal procedure in depriving citizens of life, liberty, or property. This procedure has, beginning with Chicago, Burlington, and Quincy Railroad Company v. Chicago, been expanded to encompass judicial procedures outside the realm of procedural law. Continuing with the incorporation of the freedom of speech in Gitlow v. New York, in which the court asserted that the freedom of speech was among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states, the court has subsequently used due process to incorporate most other provisions of the Bill of Rights. Given the Supreme Court's adherence to the principle of stare decisis, it would be unreasonable to urge the court to overturn decades of precedent by using privileges or immunities for incorporation. The Due Process Clause may even expand as far as what has been dubbed substantive due process. The Due Process Clause ensures that no state shall deprive any person of life, liberty, or property without due process of law. Thus, any law that deprives people of their life, property, or liberties, especially those in the Bill of Rights, without a justification from the government, is against the 14th Amendment. This interpretation is admittedly more controversial, with justices like Thomas and Holmes strongly opposed to its use. Although the court has repeatedly found that stare decisis outweighs these concerns. Justice Scalia, who was the dominant originalist on the court, found in his concurrence in McDonald v. Chicago that I have acquiesced in the court's incorporation of certain guarantees in the Bill of Rights because it is both long established and narrowly limited. Furthermore, Scalia's concerns surround substantive due process, not procedural due process, and as will be argued, excessive fines fall under the procedural due process category. Thus, from both an originalist and a doctrinalist standpoint, the excessive fines clause should be incorporated through due process, but as for the other rights in the Bill of Rights, substantive due process is a perfectly legitimate approach.
Does it matter which part of the 14th Amendment we use to incorporate the excessive fines clause? Please cite past court cases and historical materials to support your position.
Incorporation under due process is highly significant. The Due Process Clause stipulates that no person shall be denied due process of law. The Privileges or Immunities Clause, however, applies only to, quote, citizens of the United States. Much precedent, such as Zadvitas v. Davis, has shown that the Due Process Clause applies to all people within the United States, not merely citizens. Although every state constitution has a clause prohibiting excessive fines, it is important that the state's application to all people at the state level be recognized by the highest court in the land. Using the Due Process Clause also avoids setting a dangerous precedent for privileges and immunities, which, as privileges and immunities, strips the court of its ability to only incorporate those amendments, quote, fundamental to the American scheme of justice. Additionally, in the cases of Santa Clara County v. Southern Pacific Railroad Corporation, First National Bank of Boston versus Bellatoni, Citizens United versus FEC, and most recently Burwell v. Hobby Lobby Stores, the court has held that the due process of law allows for all legal persons, including corporations, to receive due process rights.
Why shouldn't we, the justices, apply the excessive fines clause to the states via the Privileges or Immunities Clause of the 14th Amendment?
Using privileges or immunities conflicts with the Equal Protection Clause of the 14th Amendment. The use of due process for incorporation ensures that everyone in the United States receives those rights deemed fundamental to the American scheme of justice, not simply citizens of the United States. As mentioned earlier, the Bill of Rights never uses the word citizen, instead referring explicitly to the people in the First, Second, Fourth, Fifth, and Sixth Amendments. On the other hand, the Privileges or Immunities Clause singles out citizens of the United States for protection against encroachment by the states. Therefore, by using privileges or immunities, it would seem that in some cases, only U.S. citizens would receive protection against the states. This allows room for gross violations of the fundamental rights of persons within the United States who do not yet have citizenship status. In fact, if slavery were still in existence, this clause would do nothing to protect enslaved people who were denied citizenship under the infamous Dred Scott decision until the passage of the 14th Amendment. This seems contrary to the original intent of the 14th Amendment, which was to provide freemen with the same legal rights as white people, in part by incorporating the core of the Bill of Rights, and to provide a common set of liberties for members of all states. This can only be achieved via the Due Process Clause, which applies to all people.
In fact, the court has held that non-citizens have almost all of the rights in the Bill of Rights. In Fong Wei Ting versus U.S., the court stated, quote, Chinese laborers, therefore, like all other aliens residing in the United States, are entitled to the safeguards of the Constitution and to the protection of the laws in regard to their rights of person and of property, and to the civil and criminal responsibility. Fines are part of those rights of, quote, civil and criminal responsibility and, as previously established, are closely linked to the rights of property as well. Additionally, in Arnold v. Fainter, the court held that, quote, a state law that discriminates on the basis of alienage can be sustained only if it can withstand strict judicial scrutiny. As incorporation of the excessive fines clause via privileges or immunities would grant this right to citizens of the United States only, the government would definitely be subject to violation of the Equal Protection Clause if privileges or immunities were used to incorporate the excessive fines clause and, subsequently, the Bill of Rights.
In addition, if one assumes, as Justice Thomas does in his McDonald v. Chicago concurring opinion, that the intent of the Privileges or Immunities Clause was to automatically incorporate the enumerated fundamental rights in the Bill of Rights against the states, then incorporating one right against the states using privileges or immunities would automatically incorporate the remaining unincorporated rights in the Bill of Rights as well. As a result, Thomas's contention that one could conceivably incorporate just the excessive fines clause or just the right to bear arms does not make sense. The unincorporated portions of the Fifth and Seventh Amendments make full incorporation of the Bill of Rights problematic. The Fifth Amendment asserts that no person shall be held to answer for a capital crime unless on a presentment or indictment of a grand jury. Since the Speedy Trial Act guarantees an indictment filed within 30 days from the day of arrest, the requirement for an indictment by grand jury could make the Speedy Trial Act untenable, ironically inhibiting the accused's right to a speedy and public trial as guaranteed by the Sixth Amendment. Furthermore, capital offenses vary from state to state, so the incorporation of this tenet of the Fifth Amendment could lead to ambiguity in the administration of the law at the state level. In Hurtado v. California, the court rules that pretrial proceedings do not require a grand jury. Therefore, according to court precedent, the Fifth Amendment grand jury requirement is not among the fundamental rights of the people against the states. The Seventh Amendment is also problematic in that it guarantees in suits at common law where the value in controversy shall exceed $20 the right of trial by jury, which could lead to an explosion of civil cases requiring trial by jury should this amendment be incorporated. The state courts may not have the resources to meet this demand, leading to a backlog of civil cases and stretching the resources and time of state courts. Furthermore, in Minneapolis and St. Louis Railroad Company v. Von Bolles, the court held that the Seventh Amendment applies only to proceedings in courts of the United States and does not in any manner whatever govern or regulate trial by jury in state courts. As the court has not overturned this verdict, it is reasonable to assume that the court views the Seventh Amendment right of trial by jury for civil cases to be unnecessary for incorporation.
Does anything in particular about this case and the excessive fines clause make incorporation under the Due Process Clause appropriate?
Well, I think the excessive fines clause is especially appropriate to incorporate using due process. Excessive fines is a procedural right and not a substantive one. We are considering whether or not a state must employ a due process when it fines someone. A process, in other words, that assures that a fine is reasonable and not excessive. In Waters Pierce Oil Company versus Texas, the court clearly defined excessive fines as fines so grossly excessive as to amount to a deprivation of property without due process of law. This wording is practically identical to that of the clause in question, nor shall any state deprive any person of life, liberty, or property without due process of law. A fine is the deprivation of property, and it is only egregious when administered without due process. This is what the same phrase means in the Fifth Amendment when it says, "nor be deprived of life, liberty, or property without due process of law," and in the Magna Carta when it proclaims, "no man shall be put out of his lands or tenements, nor taken, without he be brought to answer by due process of law." Both the Magna Carta and the Fifth Amendment were highly influential in drafting the 14th Amendment. Thus, the Due Process Clause of the 14th Amendment clearly ensures that the government may not arbitrarily infringe on those rights. An excessive fine is simply any fine not sanctioned by, lacking due process of, the laws that the state has created, and as such is a procedural right, not a substantive one. The state of Indiana has drafted standards in the form of a civil code that ensures that fines are not excessive, even going so far as to include this language in their constitution. The seizure of property was fully authorized under Indiana Code Title 34, Civil Law and Procedure. The code lays out a reasonable and just due process of law that includes a path for redress if the claimant has a complaint. This also creates a clear distinction between the Due Process Clause and the Privileges or Immunities Clause. Privileges or immunities says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. In the case of Timms, the question is not whether all forfeiture laws in the abstract are unconstitutional. The question is whether or not the due process of law was followed by the Indiana state agents enforcing the law in this particular instance. And we believe the state agents did so.
The entire Eighth Amendment is a matter of the government following an appropriate judicial process. For this reason, the rest of this amendment was incorporated via the Due Process Clause. Though the excessive bail clause has not been formally ruled upon yet, footnote 12 in McDonald v. Chicago indicates that the court considers Schild v. Kubel to have incorporated the excessive bail clause under due process. In Robinson v. California, the court incorporated cruel and unusual punishment using due process. This case should therefore also be resolved with due process. The Eighth Amendment reads, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted, speaking excessive bail and cruel and unusual punishments in the same breath and pattern as excessive fines. These parallel clauses are parallel issues of the government not following an appropriate due process in punitive measures. Furthermore, the excessive fines clause is not fundamentally more suited to incorporation via privileges or immunities than any other right. Since it is not special in this regard, incorporating it under privileges or immunities would set a precedent that would lead to incorporation of the remaining clauses in the First through Eighth Amendments, with the aforementioned consequences of incorporating the clauses in the Fifth and Seventh Amendments not suited for application at a state level.
What is the scope of the Eighth Amendment's prohibition on excessive fines if we extend it to the states? How do we determine the scope of this right?
We should follow existing court precedent on how to determine if a fine is excessive or not. According to Waters Pierce Oil Company v. Texas, excessive fines are fines so grossly excessive as to amount to a deprivation of property without due process of law. Since fines are a procedural right, as has been previously argued, we first ask if the state has a due process in place to protect its people against excessive fines, and then ask if the fine imposed by the state is grossly excessive under the due process of the state's law. This mechanism preserves some autonomy of the states while still guaranteeing basic liberties to all people in the U.S. The first condition is relatively straightforward, because all state constitutions prohibit excessive fines using almost identical language to that of the Eighth Amendment. Thus, for the second condition, we can rely on the precedent set in U.S. v. Bacakagian, which calls a fine excessive if it is grossly disproportional to the crime, and U.S. v. Ursery, which distinguishes civil forfeitures from criminal punishments and decrees that civil forfeitures do not constitute double jeopardy. In other words, you cannot count civil forfeitures as being double punishment. In short, the excessive fines clause shows that fines are only excessive if the monetary value of the fine is not in line with the penalty assigned to the offense defined by state law, and if the property being forfeited is not instrumental to the crime. For other types of fines, we can simply look at the precedents surrounding other pertinent laws in the state. In Tim's case, the property was instrumental to the crime, and the state did follow due process in seizing the vehicle with a civil trial, so the forfeiture of his vehicle was not grossly disproportional to the crime.
Are civil forfeitures ever appropriate as a punishment under the excessive fines clause?
Yes, civil forfeitures are appropriate as a punishment under the excessive fines clause. As we have established, in Austin v. U.S., civil forfeitures are sometimes fines that serve as punishment, subject to the limitations of the Eighth Amendment's excessive fines clause. Clearly, this ruling shows that while civil forfeitures are punishment in some cases, they are not prohibited, they are simply subject to the limitations of the Eighth Amendment's excessive fines clause. So the forfeitures must not be excessive in order to avoid violating the Constitution. Also, in United States v. Bakacajan, this court ruled that a forfeiture is excessive if it is grossly disproportional to the gravity of the offense. So a forfeiture could be appropriate as long as it is not grossly disproportional. Furthermore, in U.S. v. Usury, the court held that in rem civil forfeitures are neither punishment nor criminal for purposes of the Double Jeopardy Clause, seeming to conclude that civil forfeitures are constitutional when a person's property is used in a crime. In fact, in his concurrence to Austin v. U.S., Justice Scalia argues that one should measure excessiveness not by the value of the forfeiture, but by the extent to which the property forfeited was instrumental to the crime, since civil forfeitures are not part of criminal procedure against the person, but actually deem the property as the defendant. Scalia clearly states the question is not how much the confiscated property is worth, but whether the confiscated property has a close enough relationship to the offense. Civil forfeitures are clearly still appropriate under the excessive fines clause if they are reasonably proportional to the crime, and more so if the person is using the property in question to commit the crime.
Assume that we incorporate the excessive fines clause in this case. Does the forfeiture of Mr. Tim's vehicle account to an excessive fine? Why or why not? Please explain legal analysis.
No, the forfeiture of Mr. Tim's vehicle is not an excessive fine. Timms relied on his Land Rover to purchase and sell drugs. The Land Rover was quite literally the vehicle used in committing the crime. As such, Tim's car was a civil forfeiture and not a criminally punitive measure. The defendant was the vehicle itself because it was used to commit the crime for drug trafficking. After all, the official name of this case is Tyson Timms and a 2012 Land Rover LR2 versus Indiana. The Land Rover is a petitioner. According to the precedent set in Austin versus United States, which established that forfeiture is a punishment subject to the limitations of the Eighth Amendment's excessive fines clause, we must decide if the seizure of Tim's Land Rover was excessive, and it wasn't. Well, the petitioner argues that the vehicle, which was worth $42,058.30 when Timms purchased it, exceeds the maximum statutory fine of $10,000 for his Class B felony. The petitioner is ignoring the fact that the vehicle is a civil and not a criminal forfeiture and is thus subject to different restrictions than criminally punitive fines. As we have already established, one should measure excessiveness not by the value of the forfeiture, but by the extent to which the property forfeited was instrumental to the crime, since civil forfeitures are not part of criminal proceedings against a person, but actually deem the property as the defendant. Timms had an established pattern of using his vehicle to commit the felony of drug trafficking. So, the confiscated property is inextricably intertwined with the offense. Seizing the vehicle was a result of the vehicle's status as an accessory to a felony and not just a means of enriching the state or punishing Timms. As a result, the state followed due process of law when seizing the Land Rover, and the forfeiture is not grossly disproportional to the gravity of the offense, according to the standard set in U.S. v. Bakacajan. It is reasonable and not at all excessive that the state deprived Timms of a vehicle he drove more than 16,000 miles to transport heroin.
Given the amount of precedent in support of the incorporation of the excessive fines clause, the central question is not whether to incorporate, but rather how to incorporate. Since the other portions of the Eighth Amendment have been incorporated using due process, not to mention most of the rest of the Bill of Rights, and the excessive fines clause can be construed as a procedural right, it is only reasonable to incorporate the excessive fines clause using due process as well. Even if the excessive fines clause were a substantive right, the court should recognize that the concept of substantive due process is not, in fact, a paradox, It is a rational interpretation of the phrase due process of law to mean that due process only occurs when the law in question is legitimate and constitutional. The issues of unincorporated rights and the subsequent violation of the Equal Protection Clause that would occur with privileges or immunities seal the argument in favor of due process. Timms lost his property in a just and lawful manner that did not violate the excessive fines clause of the Eighth Amendment. Nevertheless, his case brings the issue of excessive fines to light, and the due process of law clause clearly obligates the court to apply the excessive fines clause in this question of the process of forfeiture. The court would be wise to confirm the application of the Eighth Amendment to the state of Indiana and to all states in this case using incorporation via due process.
Thank you.